defamation. So we're going to get right into it. The last time defamation was tested was Feb 15. Feb 15. So it's not as rusty as product liability, but the rustiest area is negligence. That is what's really due to come up. The intentional torts just came up a few bars ago. So negligence has not come, and by the way, this does really impact how they test these areas, okay? We saw product liability literally didn't come up for like 8 bars, and then all of a sudden it came up, or maybe even more, 10 bars or so. Crimes, homicide, which used to be tested almost every couple bars, hasn't come up since 2009, all right? So it will come up. Don't think that they're just not going to bring it up. It will definitely show its head. So what we're going to be focusing on a little bit more today will be negligence. But July 2014 was the last time that negligence was tested. So torts is definitely a hot topic for this bar.
Don't they like the product liability because they can sneak in like negligence for different like subsets and stuff like that?
What do you mean by that? I don't know.
Like they can sneak in negligence, like kids running around and duty to control children and all that. Like they can always find a way to
Oh, you mean like as a sub question?
Yeah, that's the way they
I don't think there's a clear pattern on that. Not exactly, no. Not exactly. But it definitely could happen. Definitely could happen. Okay, so defamation, let's turn to your defamation approach, page 212, please. After this approach, we're going to take 5, okay? So I want undivided attention while we just get through this. I think it's a very straightforward area to write for defamation, as opposed to some of the other areas. So you will always discuss common law defamation. Always, always, always. You're looking for some type of defamatory language, publication in a newspaper. It also could be oral. And it's typically pretty clear on its face. So the first thing you want to establish is that you have a defamatory statement. Get quickly in and out. Minor issue. Of or concerning the plaintiff. Minor issue. That's published. Minor issue. Defamation is typically not a racehorse. Everyone know what I mean when I say racehorse? Meaning like 40 elements, like evidence can be. Okay? So you can take your time. You can make some good, nice arguments there, or just some nice establishing arguments, analysis of the rules. Okay? Damage depends on whether you have libel or slander. So if we look at our approach, you know what, actually I want to give a little wrinkle, excuse me. Defamatory statement can be a major issue if you have a potential statement of opinion. Okay? So if you have, this is a wrinkle to this element. Look at page 212. A defense challenge to defamation that is recognized in most jurisdictions is opinion. If the person makes a statement of opinion as opposed to fact, the statement may not support a cause of action for defamation. Whether a statement is viewed as an expression of fact or opinion can depend upon context. That is, whether or not the person making the statement would be perceived by the community as being in a position to know whether or not it is true. If your employer calls you a pathological liar, it is far less likely to be regarded as opinion than if such a statement is made by somebody you just met. Okay? So it will typically be pretty clear as to whether or not it's opinion or fact. But if you have a potential opinion, what's an example of opinion of somebody? Oh, there are so many. I could have just made a really good joke, but I'm not going to be political. So bite my tongue, but I have so many jokes I could tell this bar. Okay. So many.
Go ahead, we consent, we can take.
No, you can't. I don't get political ever. I did once, and woo, the emails that came in. Okay, so let's say CA bar style sucks. That's an opinion. It's a shitty opinion, but it's an opinion, right? It's not a fact, right? CA bar style charges for a package. Now you may think it's expensive, it's not, it's overpriced. I don't really know, I don't care. You're here, it's fine. But that's a fact. Understand? So an opinion is, I think we all know what the difference between opinions, right? Opinions are like, right, everyone has one, okay? No one's getting me, no one's is anyone getting me? Kind of? Okay, good. If you think you know the joke I was about to make on opinions, come to me at the break. I'm curious to see if anyone's like a mind reader here. But in any event, that is a wrinkle that could make this issue become a major issue. Stop and elaborate there, okay? If not, get quickly in and out. Of or concerning the plaintiff, published, damage depends on libel or slander. Go to page 213 on the bottom. Libel, the written or printed publication of defamatory language. General damages, the general injury to one's reputation are presumed. You must know that. Are presumed, who would be calling me now? But the plaintiff may offer actual evidence of damages to increase his or her award. So you're just basically stating what the damage is. Okay? They want you to know this standard. Make sure that you put it down. Don't worry too much about libel per se and libel per quad. I mean, no, it's a minority of jurisdictions. It's not heavily tested. You should have a general knowledge of it, but what you really want to know is slander next. Refers to the publication of defamatory matter by spoken words or transitory gestures. The plaintiff must plead and prove special damage in order to maintain an action when a statement is not slander per se. So special damages must be proven. So here you just need to know what they want you to distinguish if you have libel or slander and just state what the damage would be. Okay? Great. Now, this is important. If the statement was made and it is a matter of public concern, now that's relatively speaking, and we'll talk about what that means. Then you go to constitutional defamation and you attach the constitutional defamation elements to common law defamation. Okay? What is a matter of public concern? Something what? Politics, government, sports figures, but it could also be community-based. So it's not just the Kardashians, okay? It could be like in a certain fact pattern, there was a prominent attorney, for instance, or an attorney that was prominent only in a certain small town. So if it's published to the public and that person in that category, in that group, in that community cares about what that person is about, their reputation, then that's a matter of public concern. So it's not the country. It could be a very small group of people, okay? But let's just say a community base. There is a community base for that person's reputation, okay? So don't be tricked to think, oh, this is, a private individual. Well, if it's just someone walking down the street, that's different. But if it's someone that has an established business in Encino, right? So the citizens of Encino, the community of Encino cares about the reputation of that business, right? That's something that could be a matter of public concern. So if you have a matter of public concern, then you go into your constitutional defamation. Establish the matter of public concern. Page 214, a plaintiff must establish the oral or written statement of the defendant is a matter of public concern. This is typically a question of fact. Don't spend too much time there, but definitely establish it. Falsity of the defamatory statement. The plaintiff must prove the statement is inaccurate. This must be discussed. This is a highly missed issue here. I'm not really sure why, but it's worth at least, I would say, 5 to 7 points. The plaintiff must prove the statement is inaccurate. Exam tip, page 214. If a statement of public concern is true, the plaintiff has no cause of action for defamation. However, if you see this type of statement on the exam, consider whether the plaintiff may have a cause of action for intention, IIED, or invasion of the right to privacy. We'll talk about that in a moment, okay? You're not going to bring it up right here, okay? We never mix apples and oranges within a cause of action, right? So we never, for instance, in intent to kill, I know I'm kind of like backtracking, but in intent to kill, let's say we don't see an intent, but we see a provocation. Are we going to, if you watch that lecture, are you going to bring up provocation right there? Or are you going to wait for voluntary manslaughter? You're going to wait, right? So same thing here, okay? But it's just getting you thinking of other causes of action. Okay, so establish the falsity and then go into fault. Fault on the part of whom? The defendant. Good. Now the fault and level of fault depends on whether we have a public figure or a private figure. So top of page 215. Public official or public figure malice. Okay? A public figure is one that is defined as someone achieving pervasive fame or notoriety. Example, a sports figure, or, page 215, I'm under the heading public figure, okay? By voluntarily assuming a central role in a particular public controversy. So that's what I was talking about, okay? Like a community activist, for instance. So if the plaintiff is a public figure, then you have to prove malice. Knowledge, this is a very, very hard, this is why defamation is so hard to prove, by the way. This is why whenever I get a call for someone begging me, please, they defame me. Nope, public figure, you're not going to prove malice, okay? You're not going to do it. Knowledge, think about how hard this would have to be proved. Knowledge that a defamatory statement was false or reckless disregard as to the truth of the statement. The plaintiff must show the defendant entertained serious doubts as to the truthfulness before publication. That's pretty hard. You'd have to really have substantial facts to prove that, right? Anytime you have like a state of mind element, you better have some pretty good facts. Who, what, when, where, why, okay? So don't find this element met unless you have the defendant clearly, pretty much almost to the T, knowing that the statement was not true. Okay? Everyone with me? Good. It's a subjective test. The defendant's ill will or spite is not enough to constitute malice. The defendant must be subjectively aware that the statement that he or she published was false, or that he or she was subjectively reckless in making this statement. So that's very hard to prove. Now, if you have a so you're only discussing the one that applies here, okay? You're only discussing the one that applies. Public figure malice, private figure negligence. Now, are you going into a full-blown negligence approach here? No. You're just talking about a negligent kind of standard. Page 215, or if he or she is a private figure, negligence must be shown. Ask, what was the level of reasonableness or carelessness regarding the falsity of the statement? So you want to show a level of unreasonableness, okay? That is the yardstick. That's your legal standard. Already talked about that. Okay. So just to reiterate, we have common law defamation of a defamatory statement. We can have a wrinkle of a statement of opinion of or concerning the plaintiff that is published. Then we have damage, which depends on libel or slander. If you have a matter of public concern, you go into constitutional defamation. You have to identify the matter of public concern, identify the falsity of the statement. Fault depends on if we have a public or private figure. Going back here, if you do not have a matter of public concern, you see that there's an arrow going right to where? The defenses. Okay? Consent, truth, and privilege. Those are your three main defenses. Bring them up every single time, even if they don't apply. You see, I'm a stickler on defenses. I'm a stickler on defenses for a couple of different reasons. Number one, you have to consider a defense to a cause of action in the law. It's if the question is asking you, can the defendant be liable? How are you going to determine that if you don't consider the defenses, right? It just wouldn't make sense. The second reason I'm a big stickler for them is if you've missed issues or points here, let's pick them up on hitting those defenses, okay? So I want you to be as full circle as possible. If you do have a constitutional defamation claim as well, then you go into the defenses at the end. Okay, we're not done yet with this. We're almost done for our break. Now, if you are in a general defamation question, general meaning there's a messed up statement made about somebody, okay? The plaintiff wants to sue. Obviously, right away, plaintiffs want to sue on defamation, right? However, if you can't prove defamation, you have to then consider one or more of the 4 privacy torts or intentional infliction of emotional distress. This is where a defamation essay can turn into a doozy, okay? This is where it can turn into a long essay. Please don't walk out. I'm saying in general, like, don't walk out. I saw faces go, oh God, please, I hope we don't get this one. If that happens, you take a deep breath, you go, what are the elements? Torts is highly elemental. It's probably the most elemental area in the law. And you go through the elements. Now, for the privacy torts, there is an approach for them, okay? I'm not going to map it out on the board because it's literally just Iraq. But you should know all of the privacy torts. They start on the page 216. You have misappropriation of plaintiff's picture or name. So just to be clear, these can be a specific question, right? Specifically asking you for one or more of these privacy torts. These are super due to come up, okay? And this is like an area where applicants don't really study. They're like, nah, those are not going to come up, okay? So make sure you know these, all right? And again, in a general defamation question, they could cross over. You may need to bring them up as well. But think of it logically. Don't think of it only in terms of approach. If someone says something messed up about you and you can't prove defamation, you're going to want your lawyer to be skilled enough to go, okay, is there anything else we can sue under here, right? Well, if someone says something bad about you, can't you also be put into a false light, perhaps, right? So it just commonsensically relates to it, okay? That didn't even make sense. But basically, it all comes together. You would plead everything you could in a complaint for somebody making a derogatory statement that could potentially be defamatory, even if defamation and the elements in all could not be proven, okay? So we have misappropriation of plaintiff's picture or name. This is usually celebrity-based, right? Nobody cares if my picture is on a bus, but Kim Kardashian cares if her picture is on a bus because people buy a lot of stuff that she supports, and she typically would sue under this if, let's say, Greyhound put her, or let's not use that example, but a certain makeup company put her picture on their all of their ads, and she never signed off on it, okay? So that's where this tort would come into play. What do you need here? You need a defendant using the plaintiff's name or picture for a commercial purpose or commercial advantage. That's all. That's what you need. Intrusion upon plaintiff's affairs or seclusion, where a defendant intrudes upon the seclusion of private affairs of another in a way that is objectionable to a reasonable person. Turn the page. So we need physical intrusion into a place where the plaintiff has secluded himself. Can you think of an example that happens like every day in LA? Paparazzi, right? Going into like beyond the boundary of where they can go. Now there is this reasonable expectation of privacy kind of concept going on. So it has to be, if you look at the standard, okay? In a way that is not objectionable to a reasonable person, okay? But basically, eavesdropping, spying with a telescope, some other form of investigation or examination into the plaintiff's private concerns, like illegally obtaining someone's credit report, that would be fall under this tort as well. However, back to what I was saying before, if you look on 217, note, there's no requirement of a trespass to land to have an intrusion. That is very important. So if you think about paparazzi, like going in, it's not about where they are, okay? It's just about the intrusion, where one would have a reasonable, would be objectionable to a reasonable person, okay? Private affairs, intrusion into a plaintiff's private affairs constitutes affairs or areas that a plaintiff possesses a reasonable expectation of privacy. That would be highly analytical, right? So there are general areas, and you can kind of use your Crim Pro Fourth Amendment standard for this. Areas held out to the public, one has less of an expectation of privacy as opposed to in somebody's home, in somebody's car. But even that can be relative. What if you're in your car in a public place with the windows down? That's where analysis comes in, okay? So it really does depend on the facts there. There are not yardstick, like really sound places where we can always say, we can always say one has a reasonable expectation of privacy in their home, but even those kinds of cases sometimes get questioned, right? What about when someone's on their porch, and their porch is like in Venice on a public street, right? Or there's those blinds cases, right, where the blinds were open. Does one have a reasonable expectation of privacy there, right? So it's relative to the facts. That's the important part. And the intrusion must be a type that would be highly offensive to the ordinary reasonable person. So this is elemental. You're eye-racking the issues. They're all right there for you. I know it's a lot. False light is the next one. I would say that if you do have a potential defamation, you want to always discuss false light in a general question. They just go hand in hand. It's where a defendant negligently gives widespread publicity to a matter concerning the plaintiff that places the plaintiff before the public in a false light. The falsehood disclosed must be highly offensive to a reasonable person. This is a major tort that does cross over with defamation. So all you're doing here is eye-racking, literally false light, the rule, and then analyzing. That's how your setup is, a pure miscellaneous IRAC. Your default IRAC. You'll hear me say that a lot, okay? To wrap this up, we have public disclosure of private facts. How does this come up? Defendant must have committed a widespread disclosure of the plaintiff's private information. So if it's a matter of public record, this does not apply. Okay, it has to be something that is completely private, and it has to be, again, objectionable to a reasonable person. So those are your 4 privacy torts, okay? I would sit with this approach, I would outline it, I would know the elements for it. This is an area that definitely you want to give some time to, okay? Product liability, defamation, common law, constitutional law, the defenses, and then the privacy torts. Another minor wrinkle that could potentially cross here would be IIED, intentional infliction of emotional distress, in a general defamation or privacy tort type question. So anytime that someone's speaking bad about somebody else, you're thinking about intentional infliction of emotional distress. And listen, it could be a 10-point cause of action, okay? So don't think, everyone thinks IIED is just this, oh, it's IIED, it's so easy to discuss. It has points. Discuss it, okay? So I'm actually going to give you a general rule. If you're in a general defamation or privacy tort question, always discuss intentional infliction of emotional distress. You can leave it till the end, okay? If they're asking what liability, if any, what theories of liability, if any, theory or theories, okay? Theory meaning 1, defamation. Theories, defamation, false light, IIED. Okay? Don't forget that at the end of any privacy tort, you have to go into causation, page 218. The invasion of plaintiff's interest in privacy must have been actually and proximately caused by the defendant's conduct. Quickly get in and out of there. You can even do it in a one paragraph there. Emotional distress and mental anguish damages are sufficient. So damage needs to be established as well here. And the defense's truth is not a defense, consent, and the two privileges are. So what you can do if you have more than one privacy tort at issue, what you can do is you can IRAC both of them and then attach causation damages and defenses to the end of both of them. So you literally could go D for false light, do the standard, rule, analysis, conclusion, and then let's just say misappropriation, rule, analysis, conclusion. Okay, and then say, in addition to the elements required, remember transition sentences can get you right into another area. So you can say, in addition to the elements required for each privacy tort, the plaintiff must also prove. And then basically, so give a transition sentence. Now here, you may want to reiterate, depending on your analysis here, if in fact your conclusions for each one here is then going to stay or be changed. Okay? So here you may say, based on the foregoing, the plaintiff can or the defendant will clearly be liable for false light, but not for misappropriation, let's say. Okay?